Hello, I'm Tricia Bigelow from the 2nd District Court of Appeal, and with me today is Richard Couzins, also a judge retired from Placer County. We're going to talk to you about the new Prop 36, and the new Prop 36 is an amendment to the California Three Strikes Law. Prop 36 brings about two major changes to the Three Strikes Law. Changes that have not been made to the Three Strikes Law since its inception almost 28 years ago. There have been no major changes to it since that time, but we're presented with them now. And let me explain to you the two major changes. The first is there's an amendment as to who qualifies to be a third strike offender subject to a 25 to life sentence. Now, only those persons who have been convicted of serious or violent sentences will, on the current offense, will be eligible for a 25 to life sentence. All other defendants will be sentenced as second strike offenders.
Trish, does this mean that if the current crime is not serious or violent, even though the guy has 6, 7, 8 prior strikes, the sentence still would be as a second strike offender?
It seems unusual, but that is in fact the case. They could have a history of 6, 7, and more serious or violent felonies, but if the current offense is not for a serious or violent felony, they would be treated as a second strike offender. The second part of the major changes is that it allows certain defendants to petition the court for resentencing as a second strike offender. Let's talk first about the effective date of the statute. As we all know and voted on Prop 36, it was on November 6. Pursuant to the plain statutory reading of the words of Proposition 36, that statute becomes effective the next day, November 7th, 2012. Interestingly, in this statute, there is no savings clause, and by that I mean there's nothing in the statute that says this is to apply only to those offenses occurring after November 7th of 2012. Given that there is no savings clause, the Supreme Court case of Estrada would apply, and this new statute will only be applicable to cases that are not yet final, or I should say it will be applicable to all cases not yet final as of November 7th, 2012. That brings about a very important difference for certain defendants. Cases are considered not yet final if they have not been resolved by a traditional appellate review process, allowing for time for a petition for rehearing, a petition for review by the California Supreme Court, and even the time to file a writ of certiorari before the United States Supreme Court. So there's a large window of persons who will have their sentence being subject to this offense where their cases are not yet final. And it does make a difference. It makes a difference because, as you will see when we talk about this in the future, persons who have to petition the court for resentencing are required to demonstrate to the court that they will not be an unreasonable danger to the society. Or actually what happens is the court is going to make a determination of whether or not resentencing is appropriate, and resentencing must be granted if the defendant is not an unreasonable risk of harm to society. This important distinction does not apply to those cases that are not yet final. As to those cases that are not yet final, that threshold showing will not be required to be made, to be determined by a judge or otherwise. Those persons whose cases are not yet final simply qualify for resentencing under the Three Strikes Law. So let's talk about sentencing under the Three Strikes Law. As I think we're all familiar by now, any felony under the old law where there were 2 or more strikes, serious or violent felonies, regardless of what the current offense was for, was eligible for a 25 to life sentence. The new law changes that. Now the current felony must be serious or violent. If it's not, the defendant is treated as a second strike offender. I will qualify this to indicate that there are a number of exceptions in the statute that will indicate that even though the current offense is not serious or violent, the defendant will not be eligible for treatment as a second strike offender. And let's turn to those now. There are a number of exclusions. In fact, there are 4 exclusions. 3 of them are based upon the current felony for which the defendant is being sentenced, and 1 concerns the past crimes of which the defendant has previously been convicted. About these exclusions, this has come up in a number of contexts, and the statute here is specifically clear. Those exclusions must be pled and proved. So let's turn to the current felonies of which a defendant may be convicted, though not serious or violent, will make him disqualified for treatment as a second strike offender. There is a list of these crimes. It's set forth in the statute, and I'll make the caveat that what we're going to do here is just give you an overall general picture of those categories of crimes. Of course, it's incumbent upon any judge to determine very specifically by reference to those listed crimes as to whether or not they do in fact disqualify a defendant. But turning to the general nature or categories of the excluded current felonies, the first is a list of certain specified controlled substance offenses. These offenses all involve situations where there is a large amount or a large quantity of controlled substance or drug involved. The second type of excluded current felony are those where there is a conviction or, a charge for a specified sex offense. And in this list, it includes persons who are required to register under Penal Code Section 290 as sex offenders. We'll add here that you need to be careful. There's a potential pothole here for the unwary judge. Many of you are aware, and I'm sure you're in fact all aware, of the case of Hofschier from the California Supreme Court. In that case, the court made a review of certain crimes of which a defendant was convicted, some of which required mandatory registration for sex crimes, and others of which gave the judge discretion to impose sex offender registration. In comparing some of those crimes, the Supreme Court found that they, in some times, may be counterintuitive. So, for example, 290 registration may not be required, or wasn't mandatorily required for certain offenses of sexual intercourse. Yet at the same time, 290 registration was required for what could be considered a lesser intrusive crimes of sexual offenses. And so the Supreme Court determined as a matter of equal protection that sex registration under 290 would be discretionary for all of those offenses. There are, I believe, 4 offenses that would be applicable to this, 2 of which have been specifically determined.
It's very careful how you read the statute at this point. This is buried in an exclusion statute, and the statute itself says that people required to register are excluded, except, and then the statute lists a whole bunch, 6, 7, 8 crimes that will not exclude if registration is required. What we are now saying is you have to add to that list those things where Hofschier said the registration is discretionary.
Okay. Also amongst the list of those persons who will be excluded from a second strike treatment are those persons who have used a firearm, those persons who are armed with a firearm or deadly weapon, and those persons who committed crimes with an intent to cause great bodily injury. Turning first to use of a firearm and a defendant armed with a firearm or deadly weapon. The statute does not state whether or not the defendant must personally use the firearm, must personally be armed with the firearm or deadly weapon. So the question would arise whether or not, if a principal in offense was the person who used the firearm or was armed with a firearm or deadly weapon. In such instances, would the defendant also be excluded from second strike treatment? We really have no answer to that, and in our materials we discussed that perhaps this might be analogous to situations where it's questionable whether or not an enhancement may be added to a crime based on a principal use as opposed to a personal use. Looking at those case law interpretations, they indicate that when a defendant uses a firearm, personal use is required in order to use that enhancement against the defendant, a notable exception being in the gang context. Secondarily, to those persons who are armed with a firearm or a deadly weapon, the cases are split as to whether or not a person must be personally armed or whether or not they can be based on a principal being armed. So this I see as an issue that may come up. Turning to the plain language of the statute, it could be argued that use of a firearm says what it means, and there is no reference to a principal, and therefore it wouldn't apply to a principal. Do you have anything to add to that?
No, I don't. I think the case law is a little bit helpful when you analogize it to the enhancement, but by no means is it on point, and I think there's going to have to be some working through of those issues. There's another issue that occurs to me at this point. Let's say you have a defendant who's convicted of 3 crimes, and one of those crimes is on the excluded list. Do you think that bars the second strike sentencing as to the crimes that are not on the exclusion list? Is there a separation between the two? What do you think about that?
That's a good question, Richard, and interesting that you bring that up. Certainly there's nothing in the plain wording of the statute that indicates if a defendant is excluded based on a current felony that those cases where they are falling within the purview of being a second strike qualified offense, that this excluded current felonies would override and make a person not eligible as a whole for second strike sentencing. Given that there is no specific statement in the law, it seems to me a plain reading of the statute, there could be a good argument that there wouldn't be an exclusion of other persons. On the other hand, I suppose there could be an argument made that they are excluded based on the fact that, hey, an exclusion applies and the exclusion is pervasive.
You know, I think I agree with your analysis as to the fact the person can still get the benefit as to the non-excluded offenses. You know, if you look at the words of the statute, it simply says, if you have this offense, you get this sentencing. There's no other qualifiers to that. So it seems to me quite clear it's specifying the punishment for a crime, and you look at each crime and determine whether it's a qualified or non-qualified felony. If it qualifies, they get it.
Which is certainly the way traditionally we've applied third strike sentencing, and there's nothing in the statute to abrogate that.
Yeah, I think so.
Okay. Let's next turn to the fourth category of exclusions, which would make a defendant who would otherwise be eligible for treatment as a second strike offender ineligible. And that is a category of defendants who have certain prior felonies in their history. Again, even though I'm going to give you a general categories of those offenses, it's incumbent upon a judge to turn specifically to the statutory language of this new amendment to look to and determine whether or not those prior convictions apply in your particular case. The first of those prior felonies that would exclude a defendant for treatment as a second strike offender are certain sexually violent offenses. They are those listed in Welfare and Institution Code, Section 600, and they are crimes which make a defendant eligible for being a sexually violent predator. Important to note here is that the statute doesn't say that the defendant must be a sexually violent predator, but instead it indicates that if the defendant has been convicted of a crime that would qualify him for a sexually violent offender treatment. In addition, certain sex offenses where the victim is under 14 will disqualify a person for second strike treatment, as will specified homicide offenses in the history disqualify a person for treatment. Interestingly, the statute specifically does not include manslaughter. So I assume that would apply to all manslaughter convictions, voluntary, involuntary, and vehicular manslaughter, because they all come under the penumbra of being manslaughter charges. And the only exclusion is for homicide offenses. Another prior felony that will cause an exclusion is solicitation to commit murder. In addition, assault with a machine gun on a police or fireman. Possession of a weapon of mass destruction is a disqualifier, and any offense of which the defendant has been convicted by which he was punished by life or death. The question may become in this situation, will it apply to persons who are not eligible or subject to a life offense, not because of the offense itself, but because of an enhancement, the most notable being under 12022.53, where a defendant uses a weapon causing great bodily injury or death. Does that mean a defendant is disqualified for treatment as a second strike offender? Again, turning to the plain language of the statute, which we must in determining how to consider this statute, the word here used and the phrase used in the statute is that an offense punishable by a life term. It does not indicate just simply any crime or any time the defendant has been punished by a life term or subject to death. So it seems to me the enhancements would not be used under the plain language of the statute as an exclusion under this subdivision. Do you agree with that?
I agree with that. I think the statute is pretty clear about that. It's the offense that governs it, not an enhancement.
I think so too. Do you want to turn now to a discussion about consecutive sentencing?
Yes.
Okay.
While the proposition deals primarily with third strike offenders, there are two areas of important change that relate to both second and third strike sentencing. And this concerns 667C and 1170.12A. It's also important to understand that this is the only area where there are not parallel changes. Most of the time, the enactors were very careful to create parallel changes in both 667A and 1170.12. This is one area, however, where that did not happen, and we have some issues with that. I think it's important to start with the basic law first. Section 667C and 1170.12A originally had three subparts, 6, 7, and 8. Subsection 6 dealt with multiple felonies of any type. If there was a multiple felony committed that was not on the same occasion or out of the same operative facts, the statute required that there be consecutive sentencing of those counts. Subdivision 7 dealt with just serious or violent offenses. And it also said that those offenses must be sentenced consecutively if they were not committed on the same occasion or out of the same operative facts, because subdivision 7 referred to subdivision 6. The Supreme Court, in the landmark case of People versus Hendricks, has tied these two sections together so that whether it's any felony or a serious or violent felony, mandatory consecutive sentencing only arises when those crimes were not committed on the same occasion or out of the same operative facts. Subdivision 8 deals with a situation where the defendant is already serving a term when being sentenced for the three strikes offense, and it directs that the third strike sentence, or the second or third strike sentence, be consecutive to that term. Now, this was the change made to 1170.12A7. They didn't change A6, so that has been left the way it was originally worded, and still deals with any felony committed in a situation where it was not on the same occasion or the same operative facts. It must be sentenced consecutively. Subdivision 7, however, was amended to drop the reference to subparagraph 6, and instead the section now simply refers to crimes listed as strikes. The net effect of that change now will affect the way you sentence on serious and violent felony offenses. Under the new law, serious and violent felony offenses must be sentenced consecutively, regardless of whether they were committed on the same occasion or out of the same operative facts or not. It doesn't matter. Any multiple serious violent felonies are to be sentenced consecutively. It seems pretty clear to us anyway that the intent was to abrogate Hendricks and to now make the crime fit for the serious and violent offenders be a longer term where you require this mandatory consecutive sentencing. It was consistent with the intent of the legislation to do that. The legislation also changed subparagraph 8, 1170.12a8. It simply deleted that provision altogether. Which means then the net effect of that change is that now courts have the ability to sentence concurrently the crimes that are not serious or violent. You have to kind of read the lack of 8 together with existing 7 because existing 7 says that you must sentence serious or violent felonies essentially anytime you can do it, you must do it. And that, of course, would include terms otherwise serving, the defendant is already serving. But as to the non-serious, non-violent felonies that are sentenced under the three strikes law, those sentences now can be run concurrently with the elimination of Section 8, can be run concurrently with terms already being served. Here's the problem. The conflict is that these changes were made to 1170.12, but were not made to Section 667. So we have now two statutes that are dealing with the same subject in exactly opposite means. Is this a drafting error? Most likely. They simply did not pick up the fact that that law existed in both statutes. It was not changed. The question, of course, now is what to do about it. In our materials, you'll find a reference to a case called People versus Garcia. And there the court talks about the process for dealing with these kinds of conflicts that appear to be related to drafting error. You look at the intent of the legislation. The ballot statement really is a goldmine of this, and it makes clear that as to dangerous and violent offenders, they still wanted to have the long sentences, the full three strikes operation. These are dangerous and violent people that need to be kept off the streets, so the long terms apply. And by the same token, as to the non-serious, non-violent offenses, they wanted shorter prison terms, more in the line of a second strike sentence. These two aspects of legislative intent are consistent with the changes made under Section 1170.12, both as to 7 and 8. Those changes seem to be perfectly consistent with that intent. So I think if you apply Garcia, if you are convinced that that is the proper method of analysis, I think you can essentially read 667 now in the same manner as 1170.12. There may be a situation, however, where district attorneys may be tempted to charge the statute that they like for that particular circumstance.
Probably the one that will result in the longest sentence for prosecutors.
I would guess there'd be no surprise to
yes.
that. The question is, can they do it? We think there's going to be a major equal protection problem there, and that they just simply can't pick and choose what statute to sentence under. I'd like to turn now to the second major change made by Proposition 36. This is the provision that now gives the ability of certain inmates to request resentencing as a second strike offender. The enactors accomplish this by adding Section 1170.126. It's an entirely new statute which deals with this remedy. The essential process is that a person who is serving a third strike sentence now has the ability to apply for resentencing as a second strike offender if they would have qualified for second strike sentencing had they been sentenced under the new law.
And that's going to go back to persons who have been sentenced for the last 28 years, assuming they're still in custody.
Absolutely. There's no time limit at all on the statute in terms of how far they go back. It's anyone serving one of these terms.
Is there also, Dick, a time limit under which they have to apply for this petition for resentencing?
Yeah, the statute's pretty clear. You have to apply within 2 years or later with a showing of good cause. So I think we're going to see an initial glut of these petitions, and they will quickly taper off because of the time limitations. We envision that there are 4 stages to the process. The first stage is the petition itself that's prepared and filed by the inmate. The second stage is an initial screening that's done by the court to determine whether the basic elements of the statute have been met. The third is what we call a qualification hearing, and that will involve several things. It will involve a reconfirmation of the statutory requirements, as well as this new element that Tricia has mentioned, the element of unreasonable risk to a danger of public safety. And then the final step would be the actual resentencing, assuming that the defendant or the inmate has established the right to the relief. Let me start with the petition itself. I want to emphasize that this applies only to third strike offenders. Regardless of the term being served by the second strike offender, they are not eligible. Even if the second strike offender is serving an indeterminate term, for example, there may have been a second-degree murder, has the prior strikes, that would be an indeterminate term, but it's not being an indeterminate term imposed because of the third strike sentence. Those inmates are not eligible. It has to be a life term being served by someone because of a third strike sentence. The petition has to request the resentencing. And it also has to contain 2 basic facts. It has to contain a list of all the crimes, the current crimes that he's now serving time for, that resulted in the 25 to life sentence. And it has to list all of the pled and proven strikes that compose that sentence. Now, there's no prescribed form for this. The inmates are going to be sending these things in all manner and shape. Obviously, the courts need to be liberal in their acceptance of these petitions. As long as they appear to comply, they will be sufficient for consideration. But you can expect that there will be wide divergence over the forms that you're going to get from these people.
Do you have any indication from CDCR that the inmates or anyone else is making some type of form petition for this?
There's no indication so far that that's the case, and one might ask whether there'll be a judicial council form. There's such a narrow window here. I think it's unlikely that the council, because of its internal checks and balances, can turn a form around so quickly. But hopefully there can be some consistency developed, perhaps through some other means, some defense services or something like that that would help standardize it.
But we may end up with a 8.5 by 11 piece of paper with pencil writing as to exactly how it is that the person is petitioning for that, and that would qualify. There's no specific procedure on the statute indicating that it has to be done by some specific means.
Right, and there's no indication, for example, it has to be verified. It's just a request. Tricia is now going to turn to that second stage, which is the initial screening.
We're calling this the second phase. It would be the initial screening after you receive the petition seeking resentencing, where it would be that the judge makes a determination of whether or not the petition is sufficient or shows a prima facie case, if you will. I'll start with indicating the fact that the statute indicates that it should be done by the original judge if possible, and I'm going to talk about that a little bit more. But here's what the petition you're going to be looking for to determine if it's complete will have. Is the defendant a third strike offender? Is he serving a life term? And is that life term based on a non-serious or a non-violent felony? If the defendant is serving the third strike sentence as a violent or serious felony, he simply will not qualify under a petition for rehearing. The second thing that a judge will have to do when they receive this petition is determine whether or not there is an exclusion that applies that will disqualify a defendant for resentencing. Now, there are two types of exclusions, and three of them. You'll be happy to know that they mirror the exclusions that we previously outlined as to whether or not a defendant, based on the current offense or based on his prior history, is ineligible for second strike offense treatment. So in other words, if it's not an excluded offense or it's not an excluded defendant, then the defendant will have made a prima facie case for purposes of the ability to seek resentencing. Again, Dick, we have this catch-all phrase, because when you review the petition, I should step back and say, when you review the petition, for most instances, it seems like a judge is going to be looking at the facts. Was the defendant convicted of a non-serious or non-violent felony? Is an exclusion applicable? And it will be pretty simple for a judge to compare the two to determine if they qualify. The only exception to that seems to be what we alluded to earlier, is that an exclusion is applicable if a defendant intended to cause great bodily injury. That may not be readily apparent from the initial screening. The procedure for initial screening, as I indicated, this must be done, and the statute specifically states that resentencings and this part seeking resentencing must occur by the original sentencing judge if that judge is available. Of course, if a judge is retired or otherwise another judge is allowed to make these determinations. For this initial screening procedure, there is no need for a defendant to be personally appearing. It's simply a review of the documents, as I've indicated. Does the defendant's prior history and current history qualify under the new rules for resentencing? Again, the only thing that may be questionable is the catch-all phrase of whether or not the defendant committed a crime with the intent to cause great bodily injury. In order to appropriately make this type of review, it seems like it would be impossible to make without ordering the defendant's rap sheet to see if there is some exclusion in the context of the rap sheet that would make the defendant ineligible for resentencing. So we are recommending that you order a rap sheet either from the prosecutor or CDCR or some other facility that can get that for you.
I might say that in that connection, in our materials you see a reference to what is available from CDCR, and CDCR has agreed to establish special liaison persons at each prison to facilitate this information being delivered to the trial courts, either because of a direct request by the prosecution or the court or whatever. So we hope that process will be facilitated and not take as long as it might otherwise.
I guess we should thank CDCR for being so helpful. Assuming you make this initial screening, you can deny the petition if that prima facie basis hasn't been shown. If the defendant doesn't show that he has met one of the qualifications in order to be subject to resentencing, you simply would deny the petition. On the other hand, if the qualifications appear to have been met, then you have no judicial discretion. You simply must grant the petition for rehearing. Let's turn to the issue that we've touched on a little bit earlier, is the issue of where there are multiple counts upon which a defendant is seeking a petition to be resentenced as a second strike offender. Now, the issue here is going to occur when the defendant may have multiple life sentences, some that are based on a serious or violent felony and some that are based on a non-violent or non-serious felony. So multiple life sentences in that situation, Or it may come up in a situation where an exclusion applies, where a defendant is excluded because of a crime that's not serious or violent, but is listed as an excluded offense, or the defendant has a prior history that would disqualify him under the exceptions. What is a judge supposed to do when you have multiple counts, some of which qualify for resentencing and some of which don't? Do you resentence only on the offenses that qualify, or do you make the determination that because there is a disqualifier, resentencing is precluded as to all of the sentences? This is not stated specifically in the statute. Again, it simply doesn't say. It seems like it might be a logical resolution to say that you would resentence as to those offenses where the defendant is not excluded and not on the other. But some might argue that this disqualification is a broader ban that would prohibit resentencing at all. What do you think?
Here again, we have that same issue we discussed earlier, as Tricia's mentioned, where the legislative intent is, frankly, a little bit ambiguous. But I think if we go back to the fundamental statutory interpretation, it simply says, if the person is serving a 25 to life sentence for an offense that is non-serious and non-violent, he can petition for relief. There's no other qualifier other than what is specified in the statute. So frankly, my interpretation is that having one disqualifying offense does not disqualify all the others that would be qualified. You'd address those, give them relief that you're entitled to, assuming you deal appropriately with the question of dangerousness, and deny the request as to the serious or violent offense.
Again, before I would make a determination on this, sitting on the Court of Appeal, I wouldn't make that without properly considering both sides of the argument, thoroughly reading the briefs, discussing it with my colleagues on the division, and hearing oral argument. And that qualifier goes to anything that I might state here today. But that does seem like at least a reasonable interpretation of the plain wording of the statute.
I'd like to turn now to the third stage. We have called this the qualification hearing. This is now after the paper review, and the matter is going to be heard by the court. We feel this is the first time where there's a right to counsel. There are obviously fundamental rights involved here in terms of the resentencing, and we feel that the defendant does have the right to have counsel. We view this hearing in two parts. The first part is the confirmation of eligibility, and then the second part is a determination of dangerousness. Turning first to that confirmation of eligibility. Remember, up to this point, there has only been a paper review by the court. The statute says that at this hearing, the court is to determine eligibility under the statute. This is an opportunity, I think, for the prosecution basically to provide additional information to the court that might indicate that the initial paper determination was flawed in some respect. Perhaps there's some additional information about priors that weren't identified or things of that nature that would disqualify the defendant. So the court is going to have to review that to determine whether the statutory basis, the pure statutory grounds apply, and that there's no exclusion that would prevent the reconsideration of the sentence. It may be that there's other evidence offered. It's a little unclear. For example, if the district attorney is intending to show that the defendant acted with intent to cause GBI, is there an ability to call new witnesses, recall the victim, for example, to give testimony?
What the standard of proof is going to be?
There's all sorts of questions there. I think the only guidance that I can say for this hearing right now, the most obvious guidance is just, again, to look at the words of the statute. This is a resentencing process. It seems to me, at basic, what would be admissible at a sentencing proceeding, an original sentencing proceeding, would be admissible in this proceeding. Whether you can bring additional witnesses in and so forth, we'll have to see. I think that's somewhat of an open question.
That question's going to include whether or not you can introduce hearsay, also whether the record of conviction that's used to prove up strikes might be the limitation on it. It is an open question, but I think largely it's just going to apply to that nebulous phrase of whether or not the defendant intended to inflict great bodily injury. Do you agree?
Yes, that's really the only area of the disqualification that frankly is a bit fuzzy. The rest are based on strict statutes, which are much clearer. It's important, if you can make this decision first, it could be decisive. As the last bullet point indicates, that if it's not confirmed that the defendant meets the statutory eligibility, you deny the petition, it's done. You don't have to get into the more nebulous issue of whether the resentencing would create an unreasonable risk of danger to public safety. So it provides sort of a subcut in this hearing, which may be useful. The second stage, assuming that the defendant is statutorily eligible after the full review of the record, is whether or not there is a determination that the court makes that the person presents an unreasonable risk to public safety if the resentencing occurs. This is obviously a safety valve that notwithstanding the paper qualification of the defendant, the court is given one last opportunity to exercise discretion, at least in a limited way, to determine whether there is simply an overriding concern about the defendant's dangerousness that should cut off any relief. It's important to understand that if the defendant does qualify after the paper review of the record, the court must sentence the offender as a second strike offender unless this dangerousness is shown. I hesitate to use the word presumption. It's not quite a presumption, but obviously the language of the statute is very strong. It's must sentence unless this is shown.
Not the full discretion that might ordinarily attach to such a hearing that considers a multiple history and factors.
Yeah, I think it's a very, very narrow bit of discretion that the court is given, although it's obviously extremely important. The court will have that discretion to make that finding. The statute outlines the things that courts can consider. The court can consider, obviously, the criminal history of the defendant. The court can consider the disciplinary record of the defendant while at CDCR. Here is a situation where it will be helpful to have the parties of the court obtain the defendant's 969B packet, for example, which contains lots of information about the conduct of the defendant in prison. Some of this information, if it's based, for example, on mental health records or things of that nature, may require a subpoena ducis tecum. But the Department of Corrections is prepared to respond to this information request and to give it to the court. And then there's that final catch-all phrase, any other relevant evidence. So it's a very broad brush that the court can sweep through to gather information in terms of this resentencing decision.
Relevant to whether or not the defendant would be an unreasonable risk of harm.
That's correct.
It is a catch-all phrase, and it's going to be interesting to see what courts decide show that.
That's correct.
In terms of the factors.
I'd like to just elaborate a little bit on the nature of the court's discretion. There's been some suggestion that it is very much like Romero relief in terms of striking a prior strike. And I think it's sort of a yes or no. In some respects it is, in some respects it's not. I think it's really important to understand that 1385 contains a distinctly different legal standard than the standard under 1170.12126. As we know, the 1385 standard, in terms of normal Romero relief, is whether the defendant falls outside the spirit of the three strikes law. But under 1170.126, it's does the defendant present this unreasonable risk to public safety? We think that is a much narrower focus, and the court has less discretion. Now, obviously, in exercising discretion, to the extent you do consider things under Romero, it's a similar process. You will obviously look at the age of the priors, the nature of the priors, what happened during the commission of the priors.
The age of the defendant.
His prospects, his family situation. All of these things are certainly relevant to a 1385 request. They will also certainly be relevant to a determination of the defendant's dangerousness.
They would fall within the catch-all provision of any other evidence relevant to the unreasonable, whether or not the defendant would present an unreasonable risk of harm.
That's correct.
Yeah.
What's important to emphasize at this point, though, is if the court is presented with a request to resentence, and the prosecution says, but Your Honor, you previously denied a Romero request, you should not focus just on that fact because the standards are different, the burden is slightly different, but as we have seen, so you should not deny the request simply because a prior Romero request was denied without making a current independent determination of the defendant's dangerousness.
It's interesting. I didn't expect the statute to have that kind of discretion vested in a judge in order to allow resentencing in the first instance. I think we all expected the statute to allow resentencing for those without serious or violent, and it's interesting there's that second layer. All right, let's talk about amendment of the pleadings and retrial. This, I think, is a very interesting issue. In 1170.126, the new resentencing statute, subdivision I, there's a little hidden phrase in there that kind of presents some interesting issues. That phrase says that a petitioner may waive his or her appearance for resentencing unless the accusatory pleading is amended or a new trial or retrial occurs. This raises the possibility of whether or not a petitioner can face amended charges or a retrial based on a plea agreement. When, of course, it's standard law and well known and set in stone that when the people make a plea agreement, and as will often happen when a person is sentenced to a life sentence, a number of other counts may be dismissed. The prosecutor thinking this person is going to prison on a life sentence, so let me dismiss many of the other charges that were less serious because I really have what I want, which is a life sentence for that person. Well, when the person comes back and seeks resentencing, a risk arises upon that resentencing. Will the people want to reinstate those charges that were previously dismissed because under the sentence that will be imposed as a second strike offense will be materially less than it would be of any life sentence? So it's interesting first that as I started out with, that this isn't something that's separately noted in the statute with perhaps a procedure or more discussion of what should happen if there is an accusatory pleading amended or there's a new trial or retrial, and that it's just stuck in the part where it indicates that a defendant can waive his right to a personal appearance. But it is there, and it raises the question, and it's fundamental law, that when a plea agreement is taken apart, everyone returns back to the status quo ante, and the people may very well wish and seek to refile those charges. It occurs to me that in order to do that, it's going to depend on a couple of factors. First of all, since this may go back as far as 28 years, heck, can the people prove those charges? Do they have the witnesses that were around before? Secondarily, you'll also have to look to the defendant's point of view. Is this going to be prejudicial to the defendant to retry charges that may be quite remote in time? And I think a Barker-Wingo analysis may be appropriate to see whether or not is the defendant at a loss as to be able to present a defense as well.
Do you think any of these concerns relate to convictions that were obtained by a trial rather than by plea agreement?
I think absolutely not, because a retrial is, an original trial is going to result in a conviction of a defendant or, on the other hand, an acquittal of the defendant on multiple charges. So the same thing isn't going to arise. A judge will have resentenced as to, the now eligible for second strike sentencing. Question may arise whether or not, and I think the judge does have discretion to do an entire resentencing and may choose on some instances where there has been a concurrent treatment to choose consecutive treatment. And that's the way I think that may cause a little wrinkle, but certainly not to amend the pleadings. Do you agree with that?
I agree with that. So it sort of seems to me this comes down to an interesting decision by the district attorney. he can either choose to do the assuming the court's going to grant the resentencing, can either choose to allow the resentencing to proceed ahead on what the defendant originally pled to, or roll the bones and put everything into play by reinstating charges, unwinding the plea deal, and going back to before any plea was entered, and then take a chance as to not only conviction of the new crimes, but also what a judge might do in terms of sentencing discretion, because the court clearly would now have broad sentencing discretion, and that new sentence would be imposed, of course, in accordance with the new law.
It would certainly seem that prosecutors wouldn't want to go this route unless it was a particularly heinous defendant or something like that that would make them want to go back to when dirt could have been warm 28 years ago and do that. All right, let's talk about what happens and what order you make as a court after this hearing, the qualification hearing. Well, obviously, if you decide that the defendant falls within the purview of being someone who qualifies for resentencing, you're going to have to resentence the defendant. You will have to state the entire new sentence, complete with a consecutive and concurrent determination, and with a statement of reasons accompanying your sentencing choices. The judge will have full discretion, it seems, to impose a sentence under all the conventional rules using the second strike parameters for those offenses with the prior offenses charged against them that make him qualified for second strike offense. By case law, clearly the sentencing judge is not free to sentence the defendant to a term longer than that which was originally imposed by the judge. But this is also an interesting turn, because when you compare a defendant who was sentenced to 25 years to life, that term has the possibility, exactly what it says, of denial by the parole board and the defendant serving the entire rest of his life in prison. Given that comparison to any imposed determinate term, the possibility of a life sentence is longer than a determinate term, which might seem counterintuitive if the term ends up being some 100 years and you have a defendant that's 60 years old before you. Unless they're, very genetically gifted, they're probably going to be serving their term by the time that they serve that determinate sentence. In any event, after the resentencing, of course, as any time that a new sentence is imposed, you'll have to have your clerk make an amended abstract, check it yourself for accuracy, and then remand the defendant to the custody of the appropriate housing agency.
Do you need to recalculate the credits?
Absolutely, you need to recalculate the credits. And it's actually not necessarily an easy task, but our memo, which will be going around, has, I believe it's the Bruner case that indicates how it is that you're to recalculate sentences in that context. All right. After that, if the defendant, and the case may be, given that the person has served a very long sentence on a life sentence, and it's recalculated under the second strike as to a determinate term, you may find that a defendant has served all of that new term under the second strike resentencing. If so, CDCR wants those defendants to be ordered to go to state parole for processing out, and the defendant may need to be on post-release community supervision, depending upon the nature of the crime. On the other hand, if the court makes the determination either that the defendant does not qualify because of an exclusion, or if the court determines that this defendant poses an unreasonable risk of harm to the public such that resentencing is not warranted, well then, resentencing is denied. You remand the defendant on the original sentence, create no amended abstract, Bob's your uncle.
Yep. You're done at that point.
Right.
And so are we. We want to thank you for the time you spent with us. We hope we've answered some of your basic questions about the new law. Hopefully you will find our memo instructive. It discusses lots of other nuances and twists and turns of the statute, but we've covered the major ones, and we hope it will be of use to you. We certainly wish you well with that. Thank you.